أعوذ بالله من الشيطان الرجيم. بسم الله الرحمن الرحيم. يا أيها الذين آمنوا اتقوا الله ولتنظر نفس ما قدمت لغد واتقوا الله اتقوا الله ولتنظر نفس ما قدمت لغد واتقوا الله إن الله خبير بما تعملون. ولا تكونوا كالذين نسوا الله فأنساهم أنفسهم أولئك هم الفاسقون. لا يستوي أصحاب النار وأصحاب الجنة أصحاب الجنة هم الفائزون. لو أنزلنا هذا القرآن على جبل لرأيته خاشعا لو أنزلنا هذا القرآن على جبل لرأيته خاشعا متصدعا من خشية الله. وتلك الأمثال نضربها للناس لعلهم يتفكرون. هو الله الذي لا إله إلا هو عالم الغيب والشهادة هو الرحمن الرحيم. هو الله الذي لا إله إلا هو الملك القدوس السلام المؤمن المهيمن العزيز الجبار المتكبر سبحان الله عما يشركون. هو الله الخالق البارئ المصور له الأسماء الحسنى يسبح له ما في السماوات والأرض وهو العزيز الحكيم. صدق الله العظيم.
صدق الله العظيم. جزاكم الله خيرا. الله يكرمك. الحمد لله نحمده ونستعينه ونستغفره ونتوب اليه ونعوذ بالله من شرور انفسنا ومن سيئات اعمالنا. من يهده الله فهو المهتدي ومن يضلل فلن تجد له وليا مرشدا. واشهد ان لا اله الا الله وحده لا شريك له واشهد ان محمدا عبده ورسوله صلى الله عليه وسلم. رسول الله صلى الله عليه وسلم في الحديث السيد ما حق امرئ ما حق امرئ مسلم له شيء يوصي به يبيت يوما أو يومين إلا إلا ووصيته عنده. MashaAllah. Abdullah ibn Umar, he listened to this hadith. Radiallahu anhu. You know, the people used to understand the importance when Prophet ﷺ opened his mouth to say something. It's a wahy, it's a revelation. There's no right of a human, a Muslim, that has something to write in his wasiyah, not to spend 1 night or 2 nights. You should write his wasiyah. It's urgency. So Abdullah, he wrote his wasiyah. Very important. Because wasiyah, it's a legal document that shows, subhanAllah, our scholar will confirm, you start it with your name, Bismillah ar-Rahman ar-Rahim, Ana Abdullah Az-Zadin Fulan Mu'adhan Sari. Ashhadu an la ilaha illallah. And then you sit down between you and yourself and you say, Ma laka wa ma alayk. The right of people over you and the right of Allah. You see, it's really courageous moments of a human being to write his will. Wallahi, I'm really grateful for our scholar and for our brother. He's a pioneer. Awad, may Allah reward him with this work.
Thank you very much.
Really, we need to put Islam in action. And not only that, wasiyah can also be demonstrating the wasiyah of Ibrahim alayhi salam, Yaqub. ووصى بها إبراهيم بنيه ويعقوب يا بني إن الله اصطفى لكم الدين فلا تموتن إلا وأنتم مسلمون لا إله إلا الله. You know, you want to die and leave your kids behind you to carry this deen. And also advise them with the salah. Without further ado, I'm going to ask Brother Muhammad to add something. I don't want to put you in the spot. Jazakallah khair. We like to, may Allah give you your health, inshallah, make dua for him. I drag him here despite his condition, but we love him in the sake of Allah.
Bismillah, alhamdulillah, wa salatu wa salam ala rasulillah. Even though he said he doesn't want to put you on the spot, he did put you on the spot. Barakallah fikum, Shaykh. I don't want to take any time away from this important presentation. So just wanted to say, alhamdulillah, it's good to see that many of you are here because this is a topic that is not really discussed enough and not talked about enough in the hadith that the Shaykh mentioned, where that none of you, what the Prophet ﷺ said, none of you that have any type of possession that will be passed on after you die should ever put their head on a pillow without having their will written out, right? So this is something of an obligation that needs to happen. And we all have heard so many stories, horror stories, of families breaking down and so many issues that arise from not having wills specified and written out and clarified and all of that. So alhamdulillah, this is good to be here. Inshallah, we are able to learn, inshallah, from our brother, the proper application
It's a beautiful
in this
month.
society where we know there are some legal concerns and legal issues that we need to be able to be equipped to deal with, inshallah. So without further ado, I'll pass on the mic to Dr. Muhammad.
Thank you very much, brother. Thank you very much for the kind introduction. Assalamu alaikum wa rahmatullah. Wassalatu wassalam ala as-sadiq al-amin. My name is... No, it's fine. Do you hear me well? Because I usually can be loud, so it doesn't even have to have a microphone.
There are people in the back.
There are people in the back. Okay. You hear me better now? Okay. Okay. So my name is Abed Awad. I'm an attorney in the state of New York and the state of New Jersey. My primary practice is in northern New Jersey. I used to practice also in New York City. I've been a lawyer for 25 years. 17 years I taught Islamic law at Rutgers Law School, at Pace Law School, and in other law schools. So I've dedicated my career studying and working with this interplay between American law and Islamic law in the Sharia. Because as we all understand that the Sharia, what we say in Arabic, manhajiyya tuntij ma'rifa. It's an epistemology that produces knowledge. And that knowledge is what we call fiqh. But the epistemology methodology itself is about the circumstances that are before the scholar. We live in Middletown, New York. We're in the United States. We live in New York. It's an equitable distribution state. Has a lot of different circumstances. So the scholars are able to look at those circumstances and develop a fiqh that will align with the needs of the community here. In my 25-year practice, I've always done some estate planning. But in the past 5 years, I've exclusively been doing estate planning, especially faith-based estate planning, Sharia-compliant estate planning. I'm also the CEO and founder of Shariawiz.com. When you get a chance, you can check Shariawiz.com. I left the flyers in my car. I will bring them to share with you. At Shariawiz.com, you're able to create your Islamic will, your Islamic trust, or your family waqf online without a lawyer. So you will save money. I'm happy to handle your cases, but in many circumstances, if your estate is not complex, you're able to do this online on that platform and save money. Now, of course, if you have a complex estate, that's going to be a different issue, and I'm going to explain some of the unique circumstances under New York law that would require you to retain a lawyer. So the Islamic law of inheritance, I'm going to do a brief intro into the Islamic law of inheritance, and the balance of my presentation will talk about what is estate planning under New York law. The Islamic law of inheritance is a mandatory intestacy system. When we say intestacy mandatory, you have very limited circumstances, discretion to deviate from the Islamic rules of inheritance. The Quran says this is an apportionment from God. So when a person passes away, his estate is going to be distributed according to those rules. The Sharia divides the Islamic heirs into 3 beneficiaries or 3 categories. These categories are the Quranic heirs, Ahl al-Fara'id, and Ahl al-Fara'id are basically in Surah An-Nisa. It is described every heir and what percentage that heir would receive, whether it's going to be 1/2, 1/4, 1/8, 2/3, 1/3, or 1/6. So that is a divine directive from Allah subhanahu wa ta'ala in Surah An-Nisa. These are the percentages that these particular beneficiaries or heirs will receive. There are 9 female and 4 male. Again, imagine the divine overarching moral Quranic perspective has always been protecting Muslim women. So there are 9 women and only 4 males that have prescribed shares in the Quran. Wife, daughter, son's daughter, mother, paternal grandmother, maternal grandmother, full sister, maternal sister, and paternal sister have exact shares mentioned in the Quran. The 4 males are a husband, maternal brother, father, and paternal grandfather. So that's the first category, Ahl al-Fara'id. The second category are people who take by ta'asib, which we describe in English the residuary takers, meaning after the folks in the first category, Ahl al-Fara'id, receive their 1/3, 1/6, whatever their share is, if anything remains in the estate, that would be distributed to the people who take by ta'asib. And the people who take by ta'asib are really a category of paternal heirs, and it's an order of priority. For example, if a son and daughter remain after the prescribed shares, the son and the daughter take by ta'asib مثل حظ الذكر أنثيين, double the share of the male for the female. If there were no children, then the siblings will take the balance. If there are no siblings, the nephews will take the balance. And it'll continue going in that regard. So that is taken by ta'asib. If you have no people in the first category, and you have no people in the second category of ta'asib, no paternal family, no lineage, it goes to dhul arham, which dhul arham covers. It's very rare. I've never seen it. I know the scholars have it in their fiqh books, but most of us have some kind of family. And in fact, in a lot of Muslim countries, I believe Egypt, potentially Morocco, UAE, if you only have a wife, the traditional Sharia is that the wife does not take rad, which means that if there's a balance, she takes her quarter because there are no children. And generally, the 3/4 is going to be distributed to the paternal line. But some say if there are no paternal line, she can take the balance and take the rad. So it's very unlikely for this category to apply, but again, that's something that is possible. So the most common translation is the uterine heirs, the distant kindred, the outer family. So I just explained to you what the rad is. That's one of the legal doctrines in the Sharia, is that when the total prescribed shares do not exhaust the entire estate, the balance left would go to the either by rad or by ta'asib. So this really is the simple, idiot's guide to the Islamic law of inheritance. It's very basic framework. Now, you know that the ta'asib and these prescribed shares are very complex mathematically. The science of algebra in mathematics was born to figure out how to determine the shares in inheritance. We now have technology. So at Sharia Wiz, which is the company, the website that I told you, we spent 3 years developing the platform to create the Sharia compliant wills and the Islamic trusts and so forth. But we also created the Islamic inheritance calculator. So all of the complexities here, you can go to the website, it's for free to the public, and you just answer questions on your family tree. And we go 3 generations back. It will create the inheritance distribution according to the Sharia, provide you with the isnad, the Sharia ruling, plus it will give you the Quranic verse or hadith that applies to the distribution. We cover all schools of law. All schools of law are very much the same, except in very rare circumstances. The Hanbalis, I believe, would allow a maternal great-grandmother to share where the other schools don't. The father blocks siblings in all schools, except I believe there's one school that may not. All of this is programmed. And also, when there is the concept of rad in the Maliki school, the traditional old school of the Malikis is that rad doesn't go back to the balance of the family, but rather goes to Bayt al-Mal. But all of these have become more uniform between the schools. So in the US, we live in a secular civil country. If you pass away in New York without a will or a trust, your estate is going to be distributed according to New York law. And according to New York law, the first 50,000 goes to your wife, then the balance 50% goes to the wife, and then the other balance 50% will go to your children. In New Jersey, 100% goes to your wife. So if you don't have a will, your parents don't inherit. Your other family obligations are not there. So most scholars, Muslim scholars in the United States, have concluded that it is a fard to have an Islamic will or an Islamic trust if you live in the United States, because otherwise your estate is going to be distributed contrary to your religious faith and contrary to the Sharia. So you need to have a will or a trust. For most of us, a will is sufficient. But let me explain the difference between a will and a trust. A will is a document that contains your intentions of how you want your estate to be distributed, how you want to be buried, who would be the guardians of your children, whether you consent to an autopsy. All of that is going to be in the will. But the will becomes effective when you pass away. So you can change it anytime prior to passing away. But the will has to go to court. So when you pass away, you're going to take your family, you're going to appoint your executor, could be your wife, your husband, your brother, your older son. That person who's appointed as executor takes the will, goes to the surrogate court in Orange County, and has to probate the will, meaning he has to file it with the court. The court reviews it, determines authentication of the signatures, authentication of the document, requires noticing all of the family members, the family tree, next of kin, and after this period, the judge will enter an order appointing the executor, and that executor is able then to gather the estate and distribute the estate according to the terms and conditions of the will that you left. So it's a process, and it could be delayed, it could be protracted, it could be complicated. You may have to hire a lawyer. If you have real estate, you can have disputes between people because you don't have all the clarities that you need. So what happens is that when you probate the will, until the court enters an order, all your bank accounts, all your assets are frozen. So let's say your bank account is in your individual name. You pass away, no one can access that account until the court allows you. So we've had a lot of situations where there's a lot of complications when it's going to go through probate. Also think about it, sometimes in our community, I had a situation where somebody put a lot of cash in his safe box, so now you have to report all this information to the court because there's going to be valuation of the estate to make sure there are no taxes to the estate and so forth and so on. So the will is sufficient for most people, but a trust is different. The trust avoids court. It avoids probate. So basically, a trust is a legal document that you create. It becomes a legal entity that you transfer all of your assets into the trust. You appoint a trustee. You'll be the initial trustee. When you pass, it'll be your wife as a successor trustee. Nothing changes. There's no court. There's no registering the trust to the court. Everything, accounts, nothing changes because the accounts are a name of the trust. And then there was a trustee named Ahmed. Now the trustee is Fatima. Nothing changes. Everything stays the same. And when both people pass away, there's going to be a distribution. And when there's a distribution, it's the successor trustee who will say, okay, the trustee, the grantor of the trust, said 1/3 for 1/6 for my mom, 1/6 for my dad, the balance to my daughter, and he divides and does everything. The trustee has all that authority. So there's the difference between a will and a trust. Now, the trust always has a will, what we call a pour-over will. And in that pour-over will, it covers burial, guardianship, and so forth. So we highly advise and recommend all the time to do a trust. But sometimes if you don't have any assets, you don't own a home, you could probably get through with a will. You still need a will, even if you don't have a lot of assets, because you have, like I have somebody right now with a bank account that only has like $7,000, $8,000, and they can't get access to it. And they want to hire a lawyer, the lawyer's going to charge him $4,000 or $5,000 to put the paperwork together. So if he had a simple will, that would have appointed the family member as the executor, they take that document and they go to the bank and they take the money out. So sometimes even having a few $1,000s could turn into a complication for the family. The family's grieving, struggling of their loss. We don't want them to be worried about these things. Let's clean everything up for our families so that they don't go through this. So there are different, from an Islamic law perspective, and by the way, the concept of the trust that's in the US, it originates in Islamic law. Really well-known scholar named John Makdisi wrote this seminal piece, a law review that was called the Islamic Law Origins of the Common Law. There are two legal systems in the world. There's the civil law system and the Anglo common law system, the British system. In the civil law system, the French and Swedish and German system, they never developed a concept of a trust like the British did. So John Makdisi did a timeline history of when did the concept of trust appear in the English-British common law. And he found that it appeared around 10th, 11th century, which was the time when the Normandies had come and taken over Siqilia and occupied Siqilia. And Siqilia was very well-developed diwan and legal system, and that they learned from that diwan and transported this concept into England. So the Muslim scholars created two types of waqfs. You have al-waqf al-khayri, which is the waqf that most of us know about, which is a public waqf to help for charity. But there's also al-waqf al-ahli. And al-waqf al-ahli is also a charity, but to your family. So it could be, my assets would go, I make this waqf today, the benefit, al-manfa'a, income and benefit from this corpus, from this waqf, would go to my children, my children's children, and my children's children indefinitely. So this could go on for 100, 200 years as a trust supporting the family. So these are the differences between will and trust. But as estate planning lawyers, we talk about estate plan. We don't just talk about a will. So a will-based estate plan is a will, a living will, healthcare directive. God forbid you're disabled. You have an accident and you're brain dead. Who's gonna make all of the medical decisions for you? Do you wanna let your family know that this is what I want to happen in these circumstances? No DNR, no, I don't wanna be resuscitated. I don't wanna be living on artificial life support. You know, you can let your family know your intentions in your lifetime and who you trust to make those decisions for you. Also, you need a power of attorney. Maybe you are sick, you're disabled, you can't get to the bank. So we do an estate plan to cover in the event of death, in the event of incapacity and disability. The trust-based estate plan is the same. It's a trust, it's a will, it's a healthcare directive living will, power of attorney. So this is the whole package that will take care of you in the event of death or disability. Now, a lot of, we're here, we're living in New York. You understand that at the time of your death, there is, if you want the Sharia to govern, you have to specifically include explanations and details of these distributions in your will. You can't say, when I die, I want the Sharia to govern my estate. That will not be enforceable. No court in the US is going to do that. That would violate separation state and church. Judge is not a Sharia expert to determine that. That's why the way that we do it in my practice and the way that I had crafted and built the templates and the forms that are on Sharia Wiz, we explain with absolute detail that we have the calculator connected with our documents. It will generate the percentages in your document, and then there's a paragraph that says, if at the time I die, my heirs changed, my trustee or my executor exclusively has the right to recalculate according to the Sharia schedule that's attached to the will. So this way, no court, nobody can say that this is not enforceable. So we take those things into account. Now, there has been some clashes between many Muslims in the country, or confusion on how to deal with inheritance when they live here for their spouses. So you have a situation where you're married for 20 years. According to the Sharia, your wife is going to receive 1/8 of your estate. So a lot of Muslims come to me and say, look, we want to follow the Sharia, but my wife has been helping me. My wife has done so much for me. This is a little bit, is there a way in the Sharia to explain a way to level the playing field? And of course, as the Sharia being a methodology that produces knowledge, and the Sharia is anchored in equity and justice, there's many solutions for Muslim women. And we have codified, we have made these as options in the Sharia Wiz platform. We do it in our private practice, but if you go to the platform and do it yourself, you have those options. One, we encourage people to do gifts in your lifetime. Gifts in your lifetime solve the issue altogether. Otherwise, you have an option to give a life estate in the marital residence to your spouse, meaning the wife will remain in the house until the husband passes away. Once remains in the house until she passes away, I'm sorry. So you secured her shelter. The mahir under the Sharia is considered a debt against the estate. You voluntarily are free to amend and modify your mahar in your lifetime. You can say, the house is my mu'akhar sadaq. I want to modify it because when I got married to you, it was $100 mahar. Today I'm a physician and I'm wealthy and I'm doing well. So the wife will get the house plus she'll get 1/8. Also, in the fiqh al-Maliki, they have a fascinating concept called al-kad wa si'aya. And this concept of al-kad wa si'aya means about effort and work. And if the wife contributes to the acquisition of the marital estate, she created a legal and equitable claim to those assets. So in that, you are free to acknowledge in your will or in your trust, I acknowledge my wife had contributed to these assets. We pooled our money, she worked at the business. Half of it is for her, 1/3, or here's $200,000 to compensate her for that. That will be considered a debt against the estate. And the same thing, another way to level the playing field is the marriage contract. According to many scholars, the husband is required to provide food, shelter, and clothing. But some also say they should provide a domestic servant to help around the house. If the wife performs those services voluntarily for 20 years, that was a gift from her. It was in her good heart that she did it. She wasn't expecting compensation. But you, as a Muslim husband, you may say, I owe her for all those services and the work she did. I want to acknowledge this moral religious debt in my will, and this way she receives $100,000 to make up for everything she did over these years, plus she receives her 1/8 inheritance. So the Sharia allows, and by the way, the kad wa si'aya was a story from Al-Faruq, Umar ibn al-Khattab. There was a famous dressmaker in Mecca. She would work all night doing her dresses, give it to her husband, he would go and sell it in the market. He passed away, they had no kids. So according to the strict Sharia, 1/4 of the assets would go to the surviving wife, 3/4 would go to the paternal family. She went to As-Sadiq al-Faruq and said to him, you know what I do, I don't think this is fair. He says, yes. Half of it is yours, because you're the one working, putting these assets together, and you get your 1/4. So he flipped the formula, and this has been part of al-fiqh al-Maliki, not in the other schools. But this concept that a wife acquires a legal and equitable interest in the assets acquired during the marriage was not the law in the United States until the 1960s. So we had this legal concept 1,300 years before the United States ever even considered it. Yeah, so the problem is that our tradition is so egalitarian and gender equitable, but a lot of people are not building on it because the Sharia has to always evolve. It cannot remain static. So me specifically, most of my career, my focus has always been is that you need to work within your tradition to affect social and economic and gender equity, not outside it. We don't need to copy Western laws or copy Western feminism to empower Muslim women. Our tradition, it has the building blocks for us to build on it, but you need the scholars and the mujtahids to think outside of the box and move with the times. So these are things that we already cover in the Sharia Wiz platform, and I do it in my private practice. We also cover Huquq Allah, Zakat, Kaffarat, vows. So I'm gonna stop here and take any questions.